So could you tell us a little bit more about the dispute resolution institutions in India?
In last decade or so, so much has changed in this country in terms of ADR and institutions like LCIA India, which was established almost 12, 13 years ago. LCIA was seeing India as a huge potential market, but the institution did not survive after 5, 6 years because the driving force was not there. The education was lacking. People were very apprehensive moving to these institutions, either for arbitration services or to take any sort of mediation services. But that has rapidly changed. Now there are several institutions which have established their centers in India. There are indigenous centers like MCIA, which is in Mumbai, which is providing top class arbitration and mediation services. Delhi High Court has its own arbitration center, DIAC, as well as a very, very strong and popular mediation center called Samadhan. Very distinct from each other. Both have in their governing council some of the sitting judges and some of the senior practitioners of arbitration and mediation, respectively. It does not really, it's not really controlled by the High Court, but is of course supported by the High Court continuously, giving it the kind of reputation and support it requires in its developing stage. But just taking Samadhan as an example of a mediation institution, which has done exceedingly well in the last few years in terms of the kind of disputes that they have resolved, the kind of training programs that they have taken. I think Samadhan has its 40-hour to 60-hour training that they conduct 2 to 3 times in a year. And from that training, they empanel some mediators, and those mediators are then put with some senior mediators in the first few set of mediations to learn before they actually start mediating disputes. In your experience, you would appreciate that although mediation, of course, is a soft skill that one can learn, but it takes a lot of experience before you can actually gain that sort of confidence of the parties and are able to successfully implement that training into practice. So many of these institutions are now providing trainings in mediation and arbitration space. They are empaneling mediators and arbitrators depending on how the training is designed and what sort of experience they come up with. Something that happened recently was the Arbitration Conciliation Act, an amendment was brought in, and an institute called Arbitration Council of India was established. While it hasn't been established, but it is still there on paper, the bill has become an act, and we're waiting for further details. Government of India is, to be honest, looking for its chairperson and CEO, which the hunt is still going on. But so the Act itself provides for Arbitration Council of India, Section 43D, talks about what Arbitration Council of India is supposed to do, which is an institute which will provide training, which will promote the ADR mechanism in India, and they have given arbitration, mediation, conciliation, all the genres of ADR are covered. However, if you look at the rules below that, the rules are then restricted to arbitration. So the ACI is supposed to maintain standards of institutions, supposed to give guidelines on how to empanel arbitrators, etc. So while the thought seems to be noble, but there isn't enough for other forms of ADR in it. But I think once the ACI takes a proper shape, once it comes into force fully, there is a good possibility that ACI will also look at grading of mediation institutions, just like it is supposed to do for arbitration institution. But grading can be a very confusing term. It does not mean that they tend to regulate any of the mediation or arbitral institutions. I think Government of India has made that very, very clear. What they intend to do is to control the mushrooming of some of these institutions, because suddenly, there are several small arbitration centers which are coming up in small cities with, they just adopt the same rules of some of the known arbitration centers, try and empanel people. And the difficulty is that while it may be a great idea to have these centers in smaller towns, but the standards, if not maintained, the arbitrator appointments, if not done in a proper manner, could lead to fatal situations for parties who are, adopting any of these rules, because Arbitration Act in India, like any other developed jurisdiction, does not provide much scope for challenge of an award, and the scope is really, really narrow. So if you're stuck with a bad institution, if you're stuck with an arbitrator appointed not in terms of not maintaining good standards, etc., you may have an award which courts may not be interested in reviewing it just because you chose a bad institution and the choice of arbitrator ultimately was not the best one. So therefore, it's ACI, although was being seen as a regulator, but appears to be a necessity in terms of maintaining some standards. To maintain some standards, they have to define those standards, and ACI is likely to do that in due course. And as I said, the same sort of things may be applicable to mediation institutes and conciliation institutes also. So in terms of institutional framework, I think we have progressed. There is enough. There are some world-class institutions present in India providing ADR services. The emphasis now should be, in my mind, to train conciliators, mediators, and arbitrators in the best way possible. And then after the training, it should not be, as I said, you may gain the basic orientation of what the mediation is and how to mediate and how to arbitrate, etc. But there has to be a continuous effort to keep their skills in use and give them assignments and matters according to their background and expertise, and keep them engaged, because all these institutional framework would fail if you do not have the right service providers in terms of trained dispute resolution practitioners who are not appearing as counsels but as mediators, arbitrators, and conciliators.